Fernor, is everything okay over there?
I am living.
Alright, sounds good. Bailiff?
Recess is now over. Court is now in session again.
Alright, so let's get back to it. Senor Blackstone.
Yes, Your Honor. I believe there was an objection for leading, apparently.
Yes, Your Honor. There's an objection that the question both lacks a proper foundation and is overall vague. Like I can.
Could you re-ask your question, Senor Blackstone?
Yes, Your Honor. All right. Sheriff Fletcher, on October 2nd, on street corner, to be specific, Bay City Avenue and Cougar Avenue, did you see the defendant sell CDS?
I don't know. I'd like
Yes, I
to
did.
reinstate the objection of leading.
I'm going to sustain that one. Blackstone, you should know better. You should be able to rephrase that a little bit better.
Yeah, yes, Your Honor. On October 2nd, 2021, on the corner of Cougar Avenue and Bay City Avenue, what did you witness, Sheriff?
Well, I was on first on scene of a sale CDS call in the area. When I was down the road, I saw an individual standing in front of a blue and color sports car that was convertible. During my process of being there, I was able to see the individual, the defendant, hand off to two separate individuals before calling myself and my deputy to approach the suspect.
Okay. Did the defendant surrender?
No.
Okay. What did the defendant do?
Upon myself and Corporal Shepard arriving closer to his vehicle at the point where we're telling him to surrender, he got into his blue and color sports car and drove off from us, leading us in a police pursuit.
Okay. Alrighty then. And looking further into this here, sorry, I have to pull up timestamps here, Your Honor. I can't hear. Oh, never mind. Okay. Let's see here. All right, and all right, Exhibit A3 at 3 minutes 13 seconds. Is that your voice indicating the location where the incident is occurring?
Yes, that is my voice.
All right, now 3 minutes 51 seconds. That is your unmarked. Is that your unmarked car pulling up to the corner there?
Yes, that is correct.
All right. And then jumping ahead, after looks like approximately 11-minute chase, was that you who called out foot bail at 15:33?
I would have to review the evidence before I can actually confirm or deny that.
Go ahead.
Yes.
Hold on, Senor Blackstone. Let me stop you right there.
Okay.
Whoever is snoring in the court, they can either get the fuck out, or I'm going to charge them with contempt of court. That is extremely disrespectful.
Okay.
If I woke you up, good. You can continue to stay. Senor Blackstone, I apologize for this. Continue.
All right. Thank you, Your Honor. All right. And then at 50 minutes, 36 seconds, was that you who called out the defendant was on climbing the freight containers or cargo
Yes, that is-
container?
Yes, that is correct.
Okay. All right then. Let's see here. At 19 minutes 36 seconds. Oh, hold on. Nope. My apologies there. Make sure I'm getting this right here. At 17 minutes 55 seconds, after the defendant assaulted Deputy Stiglitz, was that you who discharged your firearm?
Your
Yes,
Honor, if
I
I
just-
may, I'm going to object again. That's a leading question, and the counsel, in effect, is testifying about what.
Your Honor, it's perfectly viewable on the evidence on Exhibit A3, 17 minutes 55 seconds. The gun's going off. I'm just confirming if that was the sheriff.
I can rebut, Your Honor.
Well, hold on. I didn't actually fully hear his question. Could you repeat it for me, Senior Blackstone?
Yes, Your Honor. I was basically asking, essentially after the defendant assaulted Stiglitz, was that the sheriff who discharged his firearm at 17 minutes 55 seconds?
And what was your objection, Senior Hall?
Your Honor, that's a leading question. Overall, the witness would have to provide that information. Of course, the prosecutor could ask what happened at a specific timestamp for the witness to describe what he sees in the body cam. But overall, that question in specific is a leading question.
I'm going to sustain that objection. Blackstone, reword that question better, please.
Sorry, Your Honor, if I could. Is there a possibility that Mr. Patterson could get some food and some water? He seems to need some at this point.
Sure. Yeah, I don't have a whole lot on me. Could we have a plate or a bailiff? Do you have any food and water on you?
I have some I can give him, Your Honor.
That would be fine. If you could just give him a little bit, that would be fine.
Thank you, Your Honor.
All
We
right.
really need to work on getting these court cases, Caden.
Okay. Am I able to continue then, Your Honor?
See, just reword your question better. We should be good.
Yes, Your Honor. Alrighty. At 17 minutes 55 seconds, Exhibit A3, who incapacitated the defendant?
That'd be myself, 401 Sheriff Marcus Fletcher.
Okay. Alrighty then. And let's see here. That's all the questions I have, Your Honor.
All right. Thank you very much.
Do you have a
Senor Hall.
Thank you. Permission to approach, Your Honor?
See, Brent.
Why did he shoot? Us?
Oh, there. Sheriff Fletcher, is that right?
Yes, sir. That is correct.
How are you doing today?
I'm doing well. I hope you are.
Oh, well, thank you very much. Now, isn't it true that previously you testified to witnessing the defendant, Mr. Pattason, meant a quote-unquote handoff?
Yes, that is correct.
What is a handoff?
Handoff is what a law enforcement officer perceives as a drug transaction where there is a local occupancy in a given area, specifically towards a defendant or suspect at that point, and they are handing brown paper bags, and it is able to be turned into evidence and processed if we find drug residue after.
Now, this all took place on Bay City Ave, right?
It was like an intersection of Cougar Avenue and Bay City. It was on the sidewalk.
Your Honor, objection. That's a leading unasked to the whatever the witness had stated be stricken from the record.
If I may, this is a cross-examination. I can lead the witness.
I'm going to overrule that objection. He does have a point, Senior Blackstone. In cross-examination, he has a little bit more leeway when it comes to the leading questions.
All right, so overall, you were by the beach, right?
No, I was not by the beach. In the general area, however you perceive, close to the beach, but no, I was not near the beach. I was in Bay City. I was more towards the uptown area. Just going near Playa Vista.
And how are you alerted that there was drug-related activities taking place in that area?
So local called in that there was suspicious activity at that location, just to reiterate, Bay City and Cougar. And then we were dispatched to the call by our dispatcher. Then that is when I called in that I was going, and that's when the event occurred.
Okay. Now, can you state exactly where this call came from and where it designated you to get?
Yeah, so at the time, I believe I was driving on Great Ocean. I can't remember the exact event that led me up there, but I was investigating surely something because I had myself and a few deputies that way. However, once we assumed that it was all clear and I went back on patrol, I was dispatched. The specific dispatch did say suspicious handoff on Bay City Ave and Cougar Ave.
Okay, so there was no other detail as to what you were looking for, is that right?
Nope, just suspicious activity. But during the nature of the call, seeing suspicious handoff, we as law enforcement officers, relate that to drug sales and those kind of calls.
Regarding the assault.
Okay, I guess.
Was it justified and all that shit? Okay.
You previously testified to yourself in this body camera footage, exhibit, I believe, A3, actually driving up to the scene and then immediately pulling the defendant over. Is that right?
Whenever I was dispatched, no, that is not true. I pulled up and observed what was going on from a distance. I believe in the report I wrote that I was about a block away. I was closer to Playa Vista whenever I got out of my patrol car and used binoculars to see what was going on at the origin of the call. And that was when I viewed the defendant making these handoffs. Two, to be exact.
Now, I noticed that you are currently wearing glasses. Are those prescription glasses?
No, I got
Objection,
these,
Your Honor,
drugstore.
relative.
And I do not wear these when I'm on patrol.
Still, it's an objection, Your Honor.
You can rebut if you'd like, Your Honor.
See,
Your
I
Honor,
think
the glasses have nothing to do with the officer being able to see.
Senior Stiegel, that is extremely disrespectful. Please allow Senior Hall to rebut your objection first.
Your Honor, I think it's highly relevant to discern whether or not this officer has any sort of issues with his sight. I mean, overall, we're determining what he saw from a block away from the scene, right? So we should clearly establish whether or not he does have prescription eyeglasses.
I'm going to,
May I bring my argument, Your Honor?
Sure.
Your Honor, all police force have to do, health check and fitness check. Otherwise, they wouldn't even be able to stay within the department. And I'm sure that the eyesight of Sheriff Fletcher is more than well to see a couple, to see one block. One block isn't that far. And if he wasn't able to see one block, he wouldn't even be able to drive a car, Your Honor.
If I may, Your Honor.
One more time, see.
Thank you. Overall, any such claims that the prosecution is making would have had to have been submitted in discovery if they're looking to back up the officer's ability to see properly. I think this is a fair question to know whether or not the officer could see what was going on a block away.
I'm going to sustain that objection because I believe that there is a way you can ask that without asking it the way that you asked it, Senior Hall.
Of course. All right. Sheriff Fletcher, do you suffer from any problems with eyesight?
No.
Now, you stated you were a block away from the incident in question, right? This quote-unquote handoff.
Yes,
where exactly
approximately.
were you positioned? You described
Yes, absolutely. So this incident happened. I was parked on Playa Vista, right, pretty much right down the road. I had straight vision to the exact scene, so wherever the defendant was. So it was a straight shot to see him. I was on Playa Vista, Bay City, like that kind of murder.
Okay. And what would you allege? Which party in this transaction would you allege that Mr. Pattison was?
Objection, Your Honor. That's a speculative question.
Well, Your Honor, I think overall we've determined that this officer has already stated that he has immense experience in determining what a quote-unquote handoff is. He can't discern what one party is in a transaction for these handoffs. Can we even necessarily trust that he knows what one of these handoffs actually is?
I'm going to overrule that objection, but please do kind of get to the point there, Senior Hall.
Of course. What party in this transaction was the defendant?
He was the, if I'm understanding your question properly, he was the person selling the narcotics.
Okay. What would you allege for the defendant to sell?
Objection, Your Honor. Speculation.
Or I can rebut if you'd like.
See,
Overall, Your Honor, the defendant is being charged with drug-related charges. I think it's not really a far reach to ask what he's being charged with selling.
I will overrule that objection.
So you're asking what I suspect that he was selling any narcotics. Those natures are very case by case, or never for sure.
Okay, what is he being charged with having sold?
Heroin.
Okay. Now, you were positioned a block away from the scene, is that right?
Approximately, yes.
Okay. And can you describe why don't you go ahead and describe this transaction? How did it occur?
So the first transaction that I made, that I could confirm with binoculars, I saw him facing towards the beach, so he would have been facing west. So I saw him on his side, and it was a hand-to-hand with a brown paper bag transaction. The second, his back was towards me. However, you can see his arm extended and a brown paper bag be received by a local through the exhibit. So on two different occurrences, I was able to see a brown paper bag.
Okay. Now, to your knowledge, is there another officer, or were you with another officer in your vehicle?
Not in my vehicle, no.
Okay. To your knowledge, is there another officer that is being called today to corroborate what you saw?
Yes.
Objection, speculation, Your Honor. That's why we have multiple witnesses.
I'll let you roll.
I'm going to overrule that. Just continue, Senior Hall.
All right. You said there was another officer that also
Yes.
witnessed this transaction.
I cannot state if he saw it for himself or not, but the other officer on scene was 427 Corporal Christopher Shepard, yes. I don't know if he saw it, though.
I believe if you look in Exhibit A3, isn't it true that Officer Shepard was down on the highway at the point that these transactions were taking place?
Those are when the dispatches were going off. He was on scene in his stakeout area before before I instructed him to move in on the subject. So he was on scene, so-called, waiting for a move-in call.
Okay, so he was, is it fair to say he was stationed perhaps a further couple blocks away from where you were?
He was actually closer to the subject than I was. He was in the, if I'm not mistaken, he was pulled into a little alleyway that was near the hotel off of Playa Vista, but he was in front of me.
Okay. And if you'd like for a moment to review Exhibit A3, and state for the court whether or not you see Officer Shepard actually witness these transactions.
Yes. Will you give me 1 second to review it on this computer here?
Senior Hall, is there a specific place that you would want him to review the A3, or are you asking him to review the entirety of that footage?
Well, Your Honor, I'm looking for him to more than likely review from either the start or close to the start, and of course to where the actual pursuit occurred.
Just by reviewing, it doesn't look like Shepard positioned himself to see the transaction. I was, per se, the scout of this transaction, so I would have been the only one. He was awaiting the move-in command.
Okay, so then it's fair to assume that you're the only officer that actually witnessed this transaction.
Yes.
Okay. Now, can you describe the individual that was the opposite or other party to this transaction, other than the defendant?
Yeah, so you're asking me to describe the locals? Well, they were definitely a local crowd. What they were wearing, I cannot recall. I'm not, unless I could look at the footage, I am not willing to say exactly what they're wearing.
Okay. So isn't it that you can recall a movement between these two individuals, but you can't recall what they look like? Is that fair?
They were definitely locals. What they were wearing, I just can't remember.
That wasn't necessarily an answer to my question. If you'd like, I can repeat.
Yeah, if you could, and maybe rephrase it.
Okay. So, isn't it true that there are lapses in your memory?
Your Honor, objection. The defense is is testifying and trying to lead into a question.
While, I mean, he is doing the cross-examination, so he's allowed a little bit of the leading. Senior Hall, where are you getting with this, with having the sheriff describe what the locals were wearing?
Of course, Your Honor. Overall, if sheriff can't actually remember what the two parties were wearing, I'd be hard-pressed to understand how he could remember a specific movement of those individuals. And overall, clear lapses in his memory.
Well, I do see several hundreds of people a day.
I'm
that
sorry,
includes...
sir, there's an objection. There wasn't a question pending.
Yeah, I'm going to sustain that objection. Yeah, I'm going to sustain that objection.
All right, Officer Fletcher. Can you state again what the individuals, both parties in these transactions were wearing?
Objection asked and answered.
Your Honor, I don't recall that there was an answer to that question.
I believe I remember him saying that he doesn't remember fully what the locals were wearing unless he was reviewing the body camera footage.
Correct.
Yep, if I could review the
so
body
I'm
cam,
going
then,
to,
yeah.
Yeah, I'm going to sustain that because he did answer that question, but in a different.
Of course,
I guess,
I'll have to
way.
rephrase it then. Can you describe exactly what the defendant was wearing?
The defendant was wearing similar to what he was wearing today. It was a tracksuit. I believe it was actually, when we apprehended him, he was wearing this exact outfit. If I could remember correctly.
Now, can you recall exactly what direction the defendant was facing when these transactions were taking place?
Yes. So the first transaction, he was facing the west, so towards the beach for the first, and for the second, his back was to me. However, his right arm was able to be extended in my sight, as well as a brown paper bag be presented in my sight.
Okay, you testified to his back being turned to you. You witnessed an object in his hand. Is that right?
A brown paper bag, yes.
Okay. Now, did you exchange? I know you stated you saw a brown paper bag, but did you ever witness cash being handed over by either party?
During these transactions, I believe the only thing that you can see is the brown paper bag. I don't know if my eyes permit me to see cash or a transaction. It's kind of like a handshake almost.
You can answer in a yes or no.
Oh, okay.
Did you see cash being transferred?
Yes, it did look like a normal transaction, hand-to-hand transaction.
Okay, you described it as a handshake.
It looked similar to that, to try putting it in context of what I can say.
Okay, so you witnessed the defendant, and you testified previously that there were 2 other parties to this transaction. Is that right?
Yes. The local that he was facing when he was facing west, and then there was another local right before he decided to move in and try apprehending the subject.
Did you ever make contact with this other party to this transaction?
I believe the local left the scene and enjoyed what I presumed and then later discovered as narcotics when he went home. So no, I did not get a chance to speak to the local.
Okay. Is it true that you analyzed the scene after this alleged transaction took place?
I'm sorry, did you ask if I processed it? Yes, I did.
The scene in question, sort of towards the beach?
Yes. After processing it, I found drug residue and then processed it.
Sorry, there wasn't a question about what you found. And my next question is going to be, overall, true that you then attempted to detain the defendant, is that right?
Yeah, yes.
What specifically did you state towards the defendant to, I guess, then submit to your authority or place him under arrest or whatever you're looking at?
When I got out of my vehicle, I believe I had my lethal drawn.
Hold on. Can you re-ask that, please, in your hall? You were mumbling halfway through that question.
What specifically did you order the defendant to do?
To stop, because at that time he was attempting to get into his vehicle.
Okay. At that time, did you have probable cause to arrest the defendant?
After seeing a drug handoff, or what I, in my law enforcement experience, perceive as a drug handoff, yes.
Okay, so you would perceive an individual having a handshake with another individual to then be probable cause for arrest.
Objection, Your Honor, speculation.
If I may, Your Honor, if the prosecutors are stating that speculation, then overall there wouldn't necessarily be a case. And if he's speculating as to what this transaction was, then I think it's...
Well, you're speculating too if a handshake means that a police officer has probable cause for an arrest.
There's an objection pending, officer.
Yep.
I'm going to overrule that objection. Continue.
So, no, my probable cause was seeing the brown paper bag being handed over to the local. I described it as a handshake-like motion to put it in terms of what I saw.
Again, you're asserting that because you saw someone, defendant, partake in a handshake-like motion, you then had probable cause to arrest him? Is that right?
With a brown paper bag involved, yes.
Okay. So at that point, legally, are you asserting that you would not actually have to investigate as far as this handoff any further? That you could just arrest him and say that's it?
That would be true. However, the defendant did get into his vehicle and then flee police. If he would have surrendered, we would have conducted an investigation, but he decided to leave the scene.
Okay.
Which,
So-
okay,
Yes. So you engaged in a pursuit, correct?
correct.
All right. How
Which
long
makes
did
me-
that pursuit take?
Approximately 11 minutes.
11 minutes. Was any
Approximately.
officer stationed on the scene while you were in that pursuit?
Christopher Shepard was my other deputy, who was my secondary in the pursuit.
That wasn't necessarily my question. My question would be, was there any officer that guarded the scene where this alleged transaction took place while you were on this pursuit?
No.
So you're on this pursuit, 11 minutes goes by, and there are no officers there on that scene protecting it.
Yeah, correct.
So at what point, after how long from when this pursuit started to then when you came back and analyzed the scene?
Once he was detained, well, actually, excuse me, after he was provided medical treatment, I believe I departed from Christopher Shepard, and then that's when I went to go process the scene. So it probably would have been roughly 5-10 minutes in between that ballpark.
Okay, so overall, I mean, we're talking upwards of 20 minutes combined?
Possibly, yes.
Now, did you see anyone on the scene when you got there, when you tried to analyze?
No.
Okay. There was no one there, but there were also no other officers there guarding you, right?
That is correct. Nobody was there, including law enforcement.
All right. Now, what did you find when you analyzed the scene?
I found some blood, and I also found drug residue, but that was it.
Okay. Whose blood was that?
Considering that I was there for narcotics, I did not intentionally collect blood. I only collected drug residue.
Okay, so there's evidence on that scene that you didn't collect.
Yes, possibly. I can't exactly recall because I could have actually picked up the blood, but I did not process the blood and run it through the database. And to that extent, just the drugs.
Can you recall whether that blood was there when this alleged transaction took place?
I'm
Can
sorry,
you repeat the question? Yeah.
Do you know whether or not there was blood there when this transaction was taking place?
Projection, yeah, speculation.
Your Honor, we wouldn't know whether this is a speculative. The witness would give a speculative answer until he answers it.
I'm still trying to figure out why are you continuing on with the blood questions if the sheriff just testified that since it was a drug call that he didn't do anything with the blood pretty much.
Of course, Your Honor. I think it's pretty clear as to what this witness has testified to, that this scene was not secure, that overall the evidence that was there was not held secure, and therefore we don't know whose blood this is. We don't know whether, this quote-unquote drug residue that was found was from this transaction or if it was something else. And that's mainly the point that I'm trying to make, Your Honor, that this scene was not secure and that it
He's
definitely can be
speculating.
contaminated.
All right. And Your Honor, if I may rebut to that.
No, I'm going to sustain that objection. Senior Hall, I think you spent a little bit and more than enough time on that line of questioning. Could you please move on to a different line of questioning, please?
Of course, Your Honor. Can I, just for clarification, is this all questioning to do with the scene or for this blood?
I guess for this blood. The only reason I'm saying that is because Mr. Fletcher here has been on the stand for a little bit long, and I don't know if he's supposed to be leaving here soon or what's the deal.
Permission to speak, Your Honor.
First granted.
Yes, I am actually anticipating leaving, hopefully to Liberty City within a few minutes, as I must.
Right, Your Honor, I have no further questions if that's okay.
God bless you.
Your Honor, can we redirect for 3 questions?
For how many?
3 or 4 questions, Your Honor, real quick, because I know that Sheriff Fletcher is on a time schedule. If it's okay with Sheriff Fletcher, obviously.
I'm going to object to that mostly because I have to take a 5-minute recess to handle something in my head. So the court will be in recess for about 5 minutes and should be back shortly.
All rise.
Okay. If Senior Fletcher is still here, you can do the questioning, but I believe he may have went ahead and took the plane.
That's fine,
Yes, Your Honor. Here they go.
Right? Prosecution, do you have a second witness?
Yes, Your Honor, I'd like to call on the stands Mr. Christopher Shepard.
All right. Mr. Shepard, you may approach.
Mr. Shepard, please raise your right hand.
Make sure to ask everything.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated.
Go ahead.
Oh, there, Corporal Shepard. How are you doing today?
Doing fantastic. How about yourself?
Doing pretty good. Alrighty. So to start off here, let's see here. Let's go to A3 since that's more relevant. Did you respond to the call at 4 seconds?
Yes, sir.
Okay. Let's see here. Who was first on scene?
It was 401 Marcus Fletcher. Sure.
Okay. Alrighty then. Let's see, make sure here. Did you see the defendant flee?
Yes, sir.
Objection, Bay.
I don't know how
I'm
that's
going to. Wait, sorry. What was that?
I didn't know how that was how that was worthy of being objected to. Unless you want me to timestamp it.
I may, Your Honor. The question was, did the defendant flee? Not the defendant flee from XYZ. Of course, there's not really a proper foundation for that question to make sense in either.
I'm going to sustain that objection. Senior Blackstone, you can rephrase that better.
Okay. Corporal Shepard, did you see the defendant flee the scene at 1 minute, let's see here, it says, my apologies, I have to read here with my glasses. Did you see the defendant flee the scene in question at 3 minutes, 53 seconds?
Yes, sir.
Okay. And just so we're aware, for the court's clarification, Exhibit A3, is Exhibit A3 your body cam?
Yes, sir.
Okay. Alrighty. Did you see the defendant going through the whole chase scene? Skipping past that. Did you see the defendant on top of the cargo containers, specifically for the defense's clarification at Buccaneer Way?
Yes, sir. And then I got a better visual as we got him down.
Okay. Now, there was a call out from an officer, specifically Stiglitz, saying he was being hit. Did you witness the officer being assaulted?
Yes, sir.
And for the court's clarification, that can be seen at 17 minutes 41 seconds through 17 minutes 49 seconds on Exhibit A3. Okay. Let's see here. sure I'm getting over here. Going through these here, Your Honor. Okay. At 19 minutes, 36 seconds, who provided medical attention to the defendant?
I was providing CPR while Fletcher was patching up the wounds.
Okay. Why was the defendant in an incapacitated state?
Because Sheriff Fletcher shot him after he knuckle busted one of our officers.
Okay. Now, I see on this report here, when we filed this, there were 2 charges of assault. Why was there a second charge placed?
So my body cam was broken up. Fortunately, the second portion was as we had him down in the cells, he actually tried to break out, and as he broke out, he punched one of our officers, and then actually took out one of the bail bondsmen.
Who did he punch?
It was a female officer. I can probably look back on my body cam footage, but yeah, it was a female officer.
Okay. Was she injured?
She had minor bruises, but the actual bail bondsman was he was incapacitated.
I see. Okay. Now, let's see here, looking at the timestamp. What force did you have to use against the defendant down at the cells?
When he was down at the cells, I was using my taser, but unfortunately, I actually pulled out my pistol as he was charging us. I was fearful whether or not he was going to knock me out and take my gun.
Okay. Now then, going back here to, let's see here, 17 minutes, 58 seconds. What was the defendant? Oh, no, my apologies. Let me rephrase that question. At Exhibit A3 at 27 minutes, 58 seconds, what was the defendant attempting?
I'm assuming bribery is the one you're trying to do. He was actually talking a bit about it while in the cells as well.
Okay. What information did he offer?
His seller, the person that provides him his stuff, essentially, so he can go sell it.
Okay. What did he ask for in return?
To go free.
Okay. And in regards to that, referencing 30 minutes, 2 seconds, did you Mirandize the defendant?
Yes, sir.
Okay. And after a little bit of back and forth conversing, let's see here, referencing 30 minutes, 26 seconds, did the defendant understand his rights?
Yes, sir. I made sure that he understood it.
Okay. Alrighty. Let's see here. And just for clarification, let's see. Let's see here. No, never mind. I'm going to withdraw that one. Let's see here. All right. That is all. Oh, actually, I do have one more, actually. Let's see here. Just referencing here. What did you find on the defendant?
On the defendant himself, he didn't really have anything that I could take because he had already taken it off himself.
Okay. No further questions, Your Honor.
Senor Hall.
Yes, sir.
And I'm going to kind of state this now. We do unfortunately need to quicken the pace because we do have another court case scheduled in 30 minutes. So I request both counselors to hurry and make their points so that we can kind of get through this case a little bit quicker.
Of course, sir. Try my best. Officer Shepard, right?
Yes, sir.
Very nice to meet you.
Nice to meet you as well.
Now, isn't it true that you testified earlier today that the second assault charge was for an alleged assault that took place on a female bail officer? Is that right? Or a female officer?
Objection, Your Honor, asked and answered to the fullest extent.
No, I'm just trying to clarify the previous testimony.
He asked and answered.
I'm going to overrule that because I do remember him saying that answer, but from what I remember, Senior Blackstone asked something like completely different. So I'm going to allow this one.
You need me to restate the question?
See.
Now, Officer Shepard, you stated previously in your testimony that there was a second female, either officer or bail officer, that was struck by the defendant, and that's where the second assault charge is coming from, correct?
Yes, sir.
Okay. Do you recall their name?
I can try to get that for you. It's again, it's on my other body cam, but it was a state police. I know that for a fact.
Okay. Would you recognize them if you saw them?
Yes, sir.
Okay. Do you see them at all in this courtroom?
No, sir.
Great. It's clear to assume that this is the victim of that assault, correct?
Yes.
Wait, hold on, back up. I'm confused. The witness just stated that it was a state police woman that was assaulted and not a bail bondsman?
Yes, Your Honor.
Your Honor, if I may rebut on that.
If there's an
Quickly.
objection.
Yes, he did state that a female officer was assaulted, but he also informed that a bail bondsman was assaulted to the point of incapacitation. There were two people hit.
I specifically did ask this witness if the second assault charge was for this female officer, and he stated yes.
Yes, sir.
Okay, sorry, continue.
Thank you. All right, and you stated again that that victim, rephrase I suppose, this second officer, the female officer, they're not in this courtroom?
No, sir. Not
They were the
this day.
victim of this assault, correct?
Correct.
And they are not present in this courtroom.
Not currently, sir.
Okay. Right. Now, suppose with all of that in mind, you were present with Officer Fletcher on Bay City Ave or Cougar Ave, correct?
Objection, asked and answered.
I'll let you roll your.
What was your question there, Senior Hall?
I was just seeking clarification that he was in fact with Officer Fletcher earlier in the day.
Yeah, I'm going to sustain that objection. He already mentioned that he was going to be.
Now, isn't it true that you never actually witnessed the handoff yourself? Officer Shepard?
Objection, leading.
Cross-examination, right?
Senior Hall has a point. Objection overruled.
So I obviously saw from a distance, but yeah, I was not able to completely confirm the handoff. So yeah, I was able to see it, but not with any close sight.
Okay, what did you see then?
So my point is, I only saw movement over there and know that a call was made beforehand, and obviously Fletcher mentioning what he saw, but I was not able to actually see any sort of like handoff or anything. If that's what you're asking.
All right, yes or no? Did you see this handoff?
No, no, sir.
So, to your knowledge, is it only Officer Fletcher that saw this handoff?
Yes, sir.
Right. Did Officer Fletcher at the time describe to you what he was seeing when he was witnessing this handoff?
Yes, sir.
What did he describe to you?
He basically said it was. He described the car. He described the suspect, and he described what was going on.
Okay. Now, you as an officer, I'd imagine you have previous experience with these types of calls, correct?
Yes, sir.
Now, with that in mind, would you assess there to be probable cause to arrest an individual based off seeing them, or giving them a handshake or giving the other a paper bag?
Definitely enough for reasonable suspicion.
Okay, but would you discern whether or not there would be enough probable cause for you to arrest that individual?
With bags being pulled off, I mean, not really. But obviously, with investigation and detainment, we would be able to find out what he had on him. But he unfortunately fled the scene.
Okay. Isn't it true that you and Officer Fletcher walked up to the defendant with the intention to arrest him?
We drove up and we had the attention. I mean, I had the intention to detain. Me and him were obviously not conversing on that portion.
Okay, it was Officer Fletcher that was leading the scene, correct?
Yes, sir.
Okay, so overall, Officer Fletcher did not communicate to you what you were going to do when you came up to the defendant?
Just that portion, I guess? No.
Okay. Now, did you see anyone else around the defendant when you actually drove up towards him?
No, sir. Just locals.
Okay, so there wasn't anyone else around him, contrary to what Officer Fletcher testified to. Is that correct?
Say again, sir. Sorry.
Of course. So, contrary to what Officer Fletcher testified, when you both drove up, there was no one around Mr. Patterson. Is that right?
There is a, if I recall correctly, there was a singular local, sir.
Okay, so there was one individual right next to him. You can't confirm for this court whether or not that's the same individual from this quote-unquote handoff, correct?
the shit that he had in this glove box, dude.
Oh, wait, so you're talking about the defendant itself?
I'm talking about this separate individual you just testified to. You cannot confirm or deny whether or not they were involved, correct?
Other than actually receiving the bags, no, sir.
Okay. For all intents and purposes, is it true or false that at that time, when you pulled up on the defendant, there was no one in the immediate area that could be attached or in any way involved in this alleged handoff, correct?
Again, other than one local, no, sir.
Did you at any point see the defendant put anything in his vehicle?
Definitely would not be able to see that when he's in front, sir.
Okay, how far away from you? How far away were you from the defendant when he got in his car?
I would say about. I can't unfortunately give you exact measurement there. It's kind of like I would say less than maybe 100 feet away.
And then what happened once you got close to him?
He immediately got into his car and drove off, going south.
Okay. Now, previously you testified to the defendant off. You said that he attempted to bribe you. Is that right?
Yeah, on the objection again, we had all those questions earlier. We're just repeating everything at this point.
To be fair, I don't believe anyone asked Sheriff Fletcher about this attempted bribery. In fact, no one even mentioned it until Senior Blackstone asked him in his original questioning. So I'm going to overrule that objection, and I want to see why he's being charged with attempted bribery in the first place.
Thank you, Honor. Do you need me to repeat the question for you, Officer?
See, please.
Yes, sir, please.
Now, can you state again at what point the defendant attempted to bribe yourself or another officer?
First was in the car when he was asking whether or not if he gives us information to free him, and then there was a second point while in the cells that he would keep saying consistently that he knew some information, and if we were to give it to him, that we would make a deal essentially to let him free.
Now, it's true that criminal informants exist, correct?
Yes, sir.
All right. And in your experience, have you ever heard of a criminal informant receiving a reduced sentence for providing information?
Yes, sir.
Okay. Now, was that offering of information a crime at that point?
I just want to state that that was not originally on our NDT report. We did not put attempted bribery, but regardless of the situation, I mean, yes, I know what an criminal foreman is, and he could be considered one, but obviously we never pursued that because, well, he kept just giving us information under Miranda.
Now, would you have, let's say that you engage in this this offer. Let's say that the defendant, he gave you this information. Would it have been a crime for you to either release him or give him a reduced sentence?
I'm not a SME on that or subject matter expert on that, so I would have probably asked someone else about that type of situation. Probably a detective.
You're a law enforcement officer, correct?
Yes, sir.
I'd assume that then you could discern what is and what is not a crime.
Yes, sir.
You have discretion when it comes to releasing or reducing charges for defendants.
It depends on what exactly it is, but yes, sir.
Okay, so I'll ask again. Would it have been a crime for either party, yourself or the defendant, if he provided you information and then you released him or gave him a reduced sentence?
No, not from what I can recall from the penal codes.
Further questions, Your Honor?
All right. Senior Shepard, you may step down. Gracias.
All right, sir. Just to ask though, sir. Will I be needed for anything else? I do have to unfortunately leave the city as well.
I do not believe so.
Your Honor, we were wanting to redirect for the witness.
Go ahead. I'm thinking about.
How pertinent is it to your case to redirect, Senior Blackstone? Because as it stands, we currently have 18 minutes before another case, and I'd like to quickly move this along.
All right. Yeah, I just have a quick question, Your Honor.
Make it quick.
Okay. Corporal Shepard,
Yes, sir.
as a corporal in the Los Angeles Sheriff's Department, do you have the authority to reduce time?
Not just off a whim. No, I cannot just reduce his time. I would have to drop a charge in order to reduce time.
All right. No further questions, Your Honor.
All right. Thank you. Thank you, Senior Shepard. You may step down.
All right, yes, sir.
We need a banger, dude. This is still kind of.
All right, you'll.
Prosecution, do you have any other witnesses?
Yes, Your Honor. We got two more, but I'll make it quick here. I'd like to call the stand Mac Foster.
Is he currently here?
Yes, Your Honor.
Yeah, sorry about that, Your Honor. That's Captain Mac Foster.
Just go for the most important: the assault, the bribery, the evading, and the vehicle. Like, make sure that the drugs. Are
Captain Foster, please raise your right hand.
If the shit is in the car, that it belongs to him, you know.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat.
Okay.
Hello there, Captain, and my apologies for the informality. How are you doing today, Cap?
Oh my
You all
God.
right?
Parkour.
Okay.
I'll just stand.
Okay. All right. How are you feeling today, Captain?
I'm fine.
All right. All right. We'll make this quick here for the sake of court. Let's see here. When did you join in on the pursuit of the defendant?
I was called to become a tertiary unit when the suspect was headed down Buccaneer Way. I caught up to the individuals as they entered the South Docks.
Okay. Did you witness the defendant driving his sports car?
I did.
Okay. Did you witness the defendant stepping out, fleeing on foot?
I did not.
Did you witness the defendant on the cargo crates?
I did.
Okay. Did you witness the officer, or did you witness the defendant assaulting Hugo Stiglitz?
I did. I jumped up onto the crates with a taser pointed at the suspect, telling him to freeze, stop, do not move, put your hands in the air. And then that's when Under Sheriff Stiglitz jumped up next to me, and that's when the suspect swung at Under Sheriff Stiglitz.
Okay. How did the defendant assault Stiglitz?
I swung at him with his right hand with a pair of knuckle dusters in his hand.
Okay. And let's see here. All right. Okay, jumping past here. Yeah. Now, aside from what was noted in exhibit, let's see, let me take a look here. Oh, what was noted in the where Fletcher had got back to the scene. There was a second scene here with the car. Did you secure that scene?
I did.
Okay. Did you search the vehicle?
I did.
Now then, given here. Is Exhibit C3 what you found in the vehicle?
I currently don't have the exhibits up on it, but I believe if you're referencing the photo I took of the vehicle, it should be 10 bottles of water, 12 bags of heroin, and 4 poppy seeds.
Okay. Are those 10 poppy seeds, is that drug paraphernalia?
It was 4 poppy seeds.
4, my apologies. Let me rephrase the question.
Mhm.
Were those 4 poppy seeds, or are those 4 poppy seeds drug paraphernalia?
According to the penal code of the state of San yes.
And being that, or actually I should ask this, at any point the defendant said the vehicle was...
Can you repeat that? You were a little broken.
Oh, sorry. At any point did the defendant say his car was stolen?
Not to me, no.
Okay. All right then.
But as I testified to about 3 questions ago, I did see the suspect driving that vehicle when I joined the chase.
Okay. All right then. And then, in your professional opinion and expertise, is that heroin in that car?
Based on my experience and training, I found a brown and color substance wrapped in individual baggies, and I believe that was sent off and tested, and it came back positive as heroin.
All right then. And you never left the scene of the car. Or sorry, let me ask the question again. Did at any point did you leave that car?
No. So when the suspect was detained and transported to medical, I stayed with the car. I called a tow truck to come down to the scene. The tow truck driver helped me lockpick the vehicle because the vehicle was locked. Once the vehicle was unlocked, I stepped in the car, secured the evidence, and then witnessed the car being put up on the tow truck and driven away.
Okay. All right then, taking a look here. Let's see here. All right. Making sure here. All right. I have no further questions, Your Honor.
All right, thank you, Senior Stiegel, or Senior Blackstone. Apologies. Senior Hall, are you ready for cross-examination?
Yes, Your Honor. Sir, can you state your name again, sir?
Captain Mac Foster with the Blaine County Sheriff's Office.
Very nice to meet you, Officer Foster.
Captain.
Apologies, Captain. All right. Now, you previously testified to searching the defendant's vehicle, is that right?
Yes, sir.
Why'd you do that?
Why did I search the vehicle?
Yes.
Because the vehicle was used in the commission of a crime.
What crime was that?
Fleeing.
Now, does fleeing assume you mean fleeing and looting or fleeing law enforcement. Does any of that have to do with possessing any sort of illicit material?
I don't
Your Honor,
understand the question.
objection, that's speculation.
Your Honor, I'm specifically asking about the law, whether or not.
Are you
fleeing
asking
from
what the definition
officers-
of fleeing is?
Oh, I'm sorry, sir. Clarifying for the judge. All right, I wasn't asking a question. What am I stating, though, is it true that the charge of fleeing law enforcement in a vehicle is a possession charge, in essence?
Are you asking me if the charge of fleeing in a vehicle
Again,
is a
Captain,
possession
I'm
charge?
clarifying for the judge. There's a pending objection. You don't need to answer.
Your Honor, I didn't even understand the question myself.
And Your Honor, if I may also rebut, Captain Foster already stated when he joined the chase. So I don't know how this is relevant to what he could understand since he was only there at the Buccaneer Way.
I'm getting
Going
toward-
to sustain the objection. Keep going, please.
Now, Captain Foster, apologies. This vehicle, you searched it because the vehicle was involved in a police chase. Is that right?
Yes, the vehicle was involved in the commission of a crime.
Okay. Now, with that in mind, at that point, did you have any probable cause to suspect there was contraband in the vehicle? I'm talking, if you could answer from the perspective of when you were on scene, not take into account anything that was learned afterward.
I knew that the pursuit started with the from a CDS call, but no, I mean, no, I didn't search the car expecting to find anything. I searched the car to inventory the vehicle and get it towed away because it was used in the commission of a crime.
Why were you going to tow the vehicle?
Excuse me?
Why were you attempting to tow the vehicle?
Objection
Because
relative.
It was used in the commission of a crime for the 5th time.
Wait, what was the objection?
We don't have a habit of leaving vehicles down. on
Please,
the
Captain
south
Foster,
lanes.
there is currently an objection. Please do not speak unless the objection is finished.
Your Honor, the objection was to relevance.
Your Honor, if I may. Specifically.
And wait, hold on. What did you ask in your home?
Yes, I was specifically asking why the vehicle was being towed. The officers basically stating that the search was because of the vehicle being towed, and I'm looking to find out why that is.
I'm going to just state this right now. I don't believe that was the right objection to use. So I'm going to object to, or not object. I'm going to overrule that objection.
Okay.
Continue, Senior Hall.
I believe you answered previously. Is that correct, Captain Foster?
I answered what?
You answered the question that was being objected to already, I believe, correct?
I believe so.
Okay. All right. Now, why is it, if I can ask, you search the vehicle, call the tow truck, you then search the vehicle. Why did you search the vehicle instead of allowing the tow truck driver to tow the vehicle away?
Because it was used in the commission of a crime.
Okay, so apparently you're stating that because a vehicle was used, an individual fleeing police, driving away from police, that means there's contraband in the vehicle for you to then search the vehicle. Is that right?
No, that's not what I said.
Okay, please elaborate.
The vehicle was searched because it was used in the commission of a crime.
Would you like to elaborate on what that means?
That means that the vehicle was used while a crime was being committed.
Okay, perhaps you'd like to include in your answer how that applies to the law and what gives you the lawful authority to search that vehicle because it was used in a crime.
Objection, Your Honor. What's the question?
Where are you going with this in your home?
Of course, Your Honor. Essentially alluding to the fact that the officer did not, in fact, have a reasonable ground to search the vehicle.
Your Honor, I think the captain made it more than enough clear that the vehicle was used in the commission of a crime, and therefore he had all the grounds to not only tow, but also inventory the car for any internal possessions and obviously external damages.
Yeah, I'm going to agree with that objection. I'm going to sustain that objection. Senior Hall, if you could kind of wrap it up with that line of questioning, because the witness here already stated 5 times he did it because it was in the commission of a crime.
Of course, Your Honor. Now, previously in your testimony, you stated that you saw the defendant attack another officer. Is that right?
Yes, sir.
Who did you see the defendant attack?
Under Sheriff Stiglitz.
Okay, in what manner?
Struck him in the face with knuckle dusters in his right hand. I believe I've answered this.
All right, now is Under Sheriff Stiglitz, he would be the victim in this crime?
Yeah, I think that's how that works.
Okay. Is he currently present in this courtroom?
Yes, he is.
Want to point him out?
He's the guy that looks like Santa Claus sitting in the front pew.
I see. Okay. All right, Your Honor, no further questions.
I think we're good.
All right. Thank you, Captain. What was it, Captain Foster?
Mac Foster, yes.
All right. Thank you, Captain Foster. You may step down from the front.
Thank you, Your Honor.
Thank you, sir.
All right, Senior Blackstone. Any more witnesses?
Yes, Your Honor. One last one, Hugo Stiglitz.
Mr. Stiglitz, could you please approach the bench?
Under Sheriff Stiglitz, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat.
Oh, there, Under Sheriff Stiglitz. My apologies for not recognizing your rank there. So I apologize.
It's all right.
Right, how are you feeling today?
Tired.
Alrighty. Now then, when did you join in on this situation that occurred on October the 2nd?
It was right at the same time Captain Foster did.
Okay. Did you witness the defendant in his sports car?
No, I didn't.
Okay. Did you see the defendant climbing the cargo containers?
Yes, I did.
Okay. Right, and let's see here. Did the defendant assault you?
Yes, he did.
Are you willing to point out the man that punched you? Or assaulted you, I should say.
That man right there sitting down with that blue jumpsuit looking thing on.
Okay.
Hey, he even waved.
Okay. What injuries did you sustain?
Hold on, Senior Blackstone. You're going to have to kind of take a cough drop or something. Your voice is cutting out there, Senior Stiglitz.
Mine's cutting out.
Is that
See-
better for you? Is that better for you, Your Honor?
No, you, Senior Black.
Oh, okay. You, I guess Under Sheriff, he's talking to you. Think about, getting the bug out of your throat.
All right.
Is that better, Your Honor, for him?
How about now?
I believe so. Yes.
Okay. Did you need me to did you need anything repeated, Your Honor?
Yes, please.
Okay. What injuries did you sustain from the assault?
I was punched in the face. Went down. Had a headache. Thought it was a concussion, but they said I was clear at the hospital.
Okay. All right. What did the defendant assault you with?
Knuckle dusters.
All right. Did the defendant assault you first?
Yes.
Okay. in your professional opinion, did the defendant show intention to harm you?
Yes.
Okay. All right, let's see here. I'm just waiting. Looking around here. Thing with this here. Alrighty. All right, I have no further questions, Your Honor.
Senior Blackstone, Senior Hall.
Yes, Your Honor. I just have a couple of questions for this witness. All right, now, Officer Stiglitz.
Undersheriff.
Apologies, Undersheriff. All right. So you stated previously in your testimony that the defendant, he hit you. Is that right?
Yes.
All right. Where in the face did he hit you?
In the face.
Okay. Now, did you see him hit you, or did too fast?
Yeah. Saw him hit me.
Okay. Now, are you aware of what the crime of battery is?
Yes.
Are you aware of what the crime of assault is?
Yes.
Okay. Are you aware that there's a difference between an assault and a battery?
Yes.
Okay. Now, it's true that the defendant, he actually made physical contact with you. Is that right? Sure.
Yes. I know he made contact with me because I went down.
All right. So he made physical contact with you. He punched you in the face. He didn't square up with you, did he? And go like, if you'd like, I can demonstrate what I mean.
Yeah, he squared up with me.
Okay, I'm gonna do a demo. Actually, can you demonstrate on the bailiff what exactly the defendant did?
Your Honor, objection. What does it have to do if he scroll up or not? The defendant clearly hit the undersheriff to the point where he fell over and needed medical attention.
Do you have a rebuttal if you'd like, Your Honor?
Quickly, Senior Hall.
First, overall, the charges of assault and battery are completely different. The crime of assault is whenever a defendant essentially alludes to the victim that they are going to cause bodily harm to them, not that they actually do it. That's a crime of battery. The crime of battery in and of itself is the unwanted physical
I
contact.
can answer the question, Judge.
Oh, Your Honor,
overall,
defense
this
is
not a question pending,
testifying.
sir, but overall, because this assault, or the defendant's charged with assault, this would mean that the defendant did not actually physically harm the victim. That's essentially what this line of questioning is for.
Your Honor, may I rebut to that?
No, hold on. Go ahead. Now put it up to assault.
Give me 1 second.
Your Honor, isn't it obvious that assault is anything from as far as a touch, even on an officer? And for the fact is, there's no battery charge listed in the penal code. I don't know where the defense is going with this difference between assault and battery when assault is any injury to the individual or even touch.
Again, if I may, the charge of battery doesn't exist, and should the state or any concerned citizen wish for it to exist, they can petition the legislature. Again, the specific argument in the line of questioning them going down is that an assault did not take place in this case. It was a battery.
Push for it. Do it. Now, I'm going to say it.
Your Honor, the penal code doesn't have any battery charges, so it falls under assault.
No,
But I'm
push
not
for
going
it.
to continue this argument for the sake of the courts.
I mean, yeah, just go ahead and then I guess, he knocked him out. Push for attempted murder, and if he doesn't want assault. Easy as that.
Hello?
Okay, hold on. So, what was the question and what was the objection? Because we got so off the rails on the question alone, it actually baffles me about
Of
this.
course, Your Honor. I was asking the witness to demonstrate how the defendant actually, quote unquote, squared up with the undersheriff here.
Okay, and
I can explain it.
Senor Stiglitz, Senor Stiegel, what was your objection?
Your Honor, it doesn't matter if the defendant squid, whatever the word is, what it says, or if he just ran against the undersheriff and punched him in the face. The result is that the undersheriff was assaulted, and it doesn't matter if he was ready to fight or not. Wherever the
All right,
defense
I'm
wants to
going
go
to
with that.
sustain that objection. Senor Hall, continue your a different question, I guess.
If you have a murder suspect, doesn't matter
Undersheriff,
if he
if you
aimed
would
or
like
not
to
aimed the gun.
describe how the event of this, him punching in the face actually took place.
Well, we saw him go up on top of the containers. So I climbed up one. There was another officer on another, and we were trying to corral him. I then pulled my taser out, and then from then he was too close for me to activate my taser, and he punched me in the face with knuckle dusters. I was
Appreciate that. Ran up, punched you in the face, and then you were knocked unconscious. Is that right?
I wasn't knocked unconscious, but I was stunned.
All right. Thank you. No further questions, Ren.
Okay, thank you, Under Sheriff Stiglitz. You may step down. Right, prosecution. Do you have any?
No, Your Honor. Prosecution rests.
The prosecution rests. All right. Defense. Do you have any witnesses to call?
You're under the defense rest as well.
I'm sorry, you cut off there. You say
Yes, the defense rests, Your Honor.
right. To the closing statement.
Yes, Your Honor. Your Honor, ladies and gentlemen of the court, given the testimonies of all the witnesses here and from the evidence shown before and brought before the courts, it is clear that the defendant is, without a doubt, guilty of the crimes that are listed below, that are listed in this document. For the first charges, assault, we have it noted from two witnesses who have testified today, or even, oh, actually, yeah, for three witnesses, my apologies, from three witnesses, Hugo Stiglitz, Undersheriff, Captain Foster, and Corporal Shepard. These three all said that Hugo Stiglitz was assaulted. And then from the testimony of Corporal Shepard, another officer, a female SASP or San Andreas State Trooper, State Police officer, was assaulted down the cells along with a member of the bail bondsman, which led to her being incapacitated, or that person being incapacitated. We've heard from the testimony of both Corporal Shepard and Sheriff Fletcher that as they approached the defendant, he, instead of complying and not doing anything, decides to jump in his vehicle and drive off, which is defined by PC 2309. With that in mind, with PC 2212, we have the testimony of Captain Foster, an expert, trained well in this, defining on what the difference is with drugs and being trained on this, found what was tested to be positive of 12 bags of heroin. On top of that, all the officers, the three who testified that Hugo Stiglitz was assaulted, all said he had knuckle dusters on him, which is defined in the penal code as being contraband. From the testimony of Sheriff Fletcher, he witnessed 2 times, he noted for the court, twice, that there was a sale of CDS, which is defined by the PC 3214. With the additional charges here, when the chase led down to Buccaneer Way, it was called out in Exhibit A3 by the sheriff, on foot, the defendant decided to bail his vehicle and decided to start climbing the cargo containers as what was defined in the timestamps noted in A3. We have the testimony of Hugo Stiglitz. It said that 2 officers were trying to climb, himself included on that, saw the defendant climb the cargo containers. Which, by that, including the driving off and fleeing, eluding, felling, evading officers, law enforcement in a vehicle, that correlates with fleeing, eluding on foot when he decided to bail his car. And because he continued to resist being arrested or detained, that correlates with PC 3306. And for the fact is, because there were poppy seeds found in the car, which is under the amount that is noted for drug cultivation, that defaults to possession of drug paraphernalia or contraband. However, in this situation here, it is proven with all the testimonies here that the defendant is guilty of all charges. And the state wishes, if he is found guilty, to be charged to the fullest extent of the law, to be charged with the total fines. That's all, Your Honor.
All right, thank you. Senior Hall.
Yes, of course, Your Honor.
Right,
Permission to approach?
Go ahead and start on your fucking opening for next case because
Senior Hall, we are past the point of this. Let's
Of
finish
course.
this case quickly.
Yes, Your Honor. I'd first and foremost like to begin with the overall, the clearest signs of innocence on behalf of the defendant. Now, I'd specifically like to address the charge of attempted bribery. From the testimony that we've heard, the evidence that was presented, we know for a fact that this was not a count of bribery. A defendant simply offering to an officer to provide confidential, incriminating information on either himself or other individuals in exchange for a lesser sentence is not bribery. It is not an unlawful act, nor would it be unlawful for that officer to accept that quote-unquote bribe or agreement and enter into an agreement with the actual defendant in this case. Therefore, it wasn't bribe. There wasn't enough evidence to even corroborate this attempted bribery. So overall, the defendant should be found not guilty on that charge. Now, I'd now like to address the charges of assault on a public servant. Now, first and foremost, the second count of this charge. Of course, the defendant was charged in relation to an assault that took place on a female trooper. Now, first and foremost, this charge in and of itself is a violation of the defendant's Sixth Amendment rights. That victim is not present in this courtroom. They were never mentioned in any evidence that was presented, other than as essentially hearsay evidence.
oh look,
Not know for a fact who this victim is, where they are now, and why they are not confronting the defendant in this case. Now, the second charge, second count of assault, which was on the undersheriff, as alleged, simply is not a case of assault. Now, the criminal code defines assault as a threat or action of bodily harm coupled with an apparent present ability to cause the harm, and does so intentionally. In the case where a threat is made against a group, only one charge will be presented. Now, overall, there is, at the end of the day, a difference between the charge of assault and the charge of battery. Unfortunately, this state does not have a charge of battery. Assault, again, is the threat of bodily harm, unwanted bodily harm to come upon the victim. The battery is that actual unwanted physical contact. Now, in and of itself, these are two completely separate charges. If a battery has taken place in this case, which in all senses it seems that it has, the defendant should have been charged with battery. And unfortunately, the state does not have a battery charge. But overall, whether or not that charge exists, the defendant cannot be found guilty a lesser assault charge when this is clearly a case of battery. Now, overall, if the state or anyone here would like the charge of battery to exist, I mean, I agree. I think it should. But overall, they must petition the legislature for that change to take effect. Overall, a defendant cannot be found guilty of an assault one charge when it is not that charge. Again, this is a case of battery. Defendant should be found not guilty of this assault charge. Now, as far as the sale of controlled dangerous substance charges and other charges of that nature, I think overall, what has been presented by the testimony from Officer Fletcher amounts to a reasonable doubt in his credibility. Overall, what we heard from his testimony is that he could not say for certain what was happening in this alleged handoff between the defendant and this other party. Overall, it is the burden of the prosecutors to prove that there was actually a handoff that was, one, unlawful, and two, contained some sort of drugs. In this case, there is not evidence to prove that. Even the testimony of Officer Fletcher was lackluster. As we saw, he was on the stand with his glasses. He had to use binoculars to see. When he was asked what he actually saw, he couldn't give a straight answer as to what he did see in this transaction. He couldn't define exactly what this other party was wearing, nor could he actually state for a fact that there was a transaction. He simply saw a handoff. Now, all of this combined does amount to a reasonable doubt that a sale of CDS took place. Overall, evidence was also presented that there was drug residue found on the same scene. Now, that could, of course, prove and somehow provide evidence that there was a sale of narcotics on that scene. However, that scene was tainted. It was left unattended for upwards of 30 minutes. In that time, who knows who could have contaminated the scene, walked up, splattered their blood everywhere, and overall provided evidence that wasn't there when this alleged handoff took place. That evidence in and of itself should be disregarded. Again, with the possible contamination of evidence, the single witness that saw this handoff that couldn't recall key details as to the handoff, all amounts to a reasonable doubt that these charges of the defendant is guilty. Since there is not enough evidence to convict the defendant on the sale of controlled dangerous substance charge, all other charges all other charges thereof would not amount to probable cause beyond a reasonable doubt either. So at the end of the day, the defendant should be found not guilty on all charges presented. Thank you, Your Honor.
All right, thank you, Senior Hall. I'm going to be putting this court in the read for about 2 minutes while I figure out what we are going to do, and then we will go from there. So, case in recess for a little bit. All right, I'm going to make this quick because we have another court case after this. A full summation for this case will be provided after I finish my next case after this. However, if the counselors want to ask about the rulings that I make, you may do so after my next case is concluded. So I'm going to make this really quick. All right, so Dolby Pattason, the state finds you guilty of one count of attempted assault, assault on a public servant, one count of felony invading in law enforcement, one count of possession of CDS, one count of possession of illegal contraband, one count of fleeing or eluding a law officer, one count of resisting arrest, one count of illegal possession of drug paraphernalia. However, the state will find you not guilty of another count of assault on a public servant, the sale of CDS, and attempted bribery. You will be sentenced to 105 months in Bolingbrook, which, to be fair, you're on the held until trial charge anyway, so it's allowed to put vote. And you'll be fined $16,300. Again, if either counselors want why I decided to make my decision, you can ask after this another court case has adjourned. And I will have a full summation after my next case is concluded. Case is now concluded.
Thank you, Your Honor.
Thank you, Your Honor.